All rise, we will away. The International Criminal Court is now in session. Lord John to Court Panel International at UAT. Please be seated. We have as well.
Yes, good morning all. I suppose we'd better call the case again. Thank you.
Good morning, Madam President. Good morning, Your Honours. This is a situation in Darfur, Sudan, in the case of the prosecutor versus Ali Muhammad Ali Abd-Al-Rahman. Case reference ICC 0205-120. And for the record, we are in open session.
Yes, thank you. We'll start this morning with appearances from the representatives of the victims.
Thank you, Madam President. Your Honours, the participating victims today are represented by Associate Counsel Anand Shah, Case Manager Saif Kassis, and myself, Nathalie von Wistinghausen. Thank you.
Thank you very much, Ms. von Wistinghausen. Defence.
Bonjour, Madame la Présidente.
Your Honor. Good morning, Your Honours. Beside Mr. Ali Mohammed Ali Abd-Al-Rahman, we have internships Claire Chauffeur, Penelope Fauré, and Salome Fischer. Assistants Ahmed Odeh and Isse, my colleague Ian Edwards from the United Kingdom, and myself, Cyril Lauchi from the Marseille Bar Association.
Well, I'm delighted to know Mr. Edwards is from the UK. And the prosecution, please.
Good morning, Your Honors. Good morning, everyone. Julia Nichols with Edward Jemery, Allison Whitford, Laura Morris, Diana Saba, Claire Sabatini, Rachel Mazzarella, and Antonella Giordano. Thank you.
Thank you, Mr. Nichols. Yes, just one thing on timing today. Judge Alapine Igonsu has official duties because she's the Vice President later this afternoon. So what we're going to do this afternoon is I'm afraid we'll shorten the lunch hour to 1 hour, so we'll have lunch, the lunch adjournment from 1 to 2, and then we'll rise at 3:30. Obviously, clearly the defence address is going to go into tomorrow anyhow, because you've got 4.5 hours. So we have the same amount of time, but we're just going to rise at 3:30 rather than before that.
That should be no problem, Madam President.
Yes, thank you. Yes, Ms. von Wistinghausen.
Madam President, Your Honours, I would like to start by greeting many of our clients who we know are today gathering in Kalma camp in Darfur and also in eastern Chad, together with our field assistants. Of course, not all of them, but some of them are there and hopefully with us remotely. And yes, I would like to take the opportunity to greet them because it's on their behalf that we are addressing you. Our closing statements will be in different parts. I will start. My colleague Anand Shah will speak about some of the topics arising from the defense brief, like jurisdictional challenges, the identification question, the alias Ali Kushaib, and the protected status of populations of Kudum and Bindisi. But let me start by this. I appear before you again as the Common Legal Representative, or CLRV, as we call it, of the today 1,592 persons who have thus far been admitted by you to participate as victims in this trial. On your screen, you will see a brief snapshot of this community of participants as they were in 2003 and 2004 at the time of the 4 charged incidents that are the subject of these proceedings. Behind each of these data points, representing a child, a woman, or a man, almost all of whom hail from the Four community, stands an individual, and I want to stress that. We're not talking about a group. It's not a victims community. These are all individuals with unique views, histories, sorrows, and hopes. I wish to convey to you the words of one of them, and you will see that our closing statement is guided by words of our clients that have been translated, but we're conveying to you verbatim what they sent. The name of this client is Hawa. She's a survivor of the charged attack on her home village of Kudum on 15 August 2003. Hawa suffered a bullet wound, and her husband and several other family members were killed. She fled to Mugjar in difficult conditions and eventually made her way to eastern Chad, where she lived as a refugee for almost 2 decades with her 2 surviving children. During a meeting with our team in July 2024, Hawa said the following: "We will leave the issue for the judges to decide, but if you ask me personally, whatever we receive, it will not equal the things that we have lost. If I lost my child, my parent, my family, they will not come back, and the pain will stay with me until I die. I cannot wash all the pain from my heart. If you see your child going without a meal, if you yourself miss 3 meals, if you would like to wash your clothes but you don't have soap since a long time, and you are hear constantly that this country is not yours, and everywhere people are trampling you, seeing you under their feet, your children cannot go to school, can go to school, but they come back home having been insulted in their hearts. If you look at the same sky," she says, "and you remember your home, but you have no right to go back home. If you see the earth, but you have no right to walk on it as you need, you have no right to farm it as you need, you have no right to build a home on it as you need, it's painful. As Darfurian people, we need our homeland. The international community time is up. We need our homeland." End of quote. The deep suffering and loss that Hawa speaks of, and which afflicts all of the participating victims, is in one manner or another, has its genesis in the devastating conflict in Darfur that took place more than 2 decades ago, including the 4 charged incidents in these proceedings centered on the predominantly 4 villages of Kudum and Bindisi in August 2003, and the towns of Mugjar and Delej in late February and early March of 2004. An arrest warrant against the accused, Ali Mohammed Ali Abd-Al-Rahman, was issued by the court more than 16 years ago. Mr. Abd-Al-Rahman's initial appearance before the judges of the pre-trial chamber took place 13 years later, in June of 2020. This trial, before your honors, commenced 22 months thereafter in April of 2022. And then, 1 year later, in April 2023, civil war broke out in Sudan, impacting all regions of the country, including Darfur, and continuing to rage 20 months on. According to the latest report of the United Nations Office for the Coordination of Humanitarian Affairs, the civil war has internally displaced 8.6 million persons, with an additional 3.1 million having fled across Sudan's border into neighboring countries, including Chad, some following the same tragic path that Hawa was forced to embark on 2 decades earlier. This report provides a conservative estimate of nearly 27,000 persons killed in the civil war and advises that, and I quote, real fatality numbers are likely significantly higher. These numbers do not include deaths from food insecurity and disease, both of which are especially acute in the Darfur region. Reliable reports further indicate that sexual violence and ethnic-based targeting have occurred on a mass scale. In our opening statement of 5th of June 2023, when the civil war was still in an early phase, we sought to convey the impact of the unfolding conflict on the participating victims, the great majority of whom continue to live as IDPs in Darfur. As the figures I have just recited indicate, and as further detailed in section 2 of our final brief, the dire situation of most of the participating victims, whether IDPs in Darfur or refugees in Chad, has deteriorated even further. Salah, a survivor of the jihad attack on Bindisi, who lives as a displaced person in the same area, provided this update by video last month.
عندما يهو اندلعت حرب بتاع 15 ابريل 2013 حصل في
بخصوص حرب 2003
معالمه ومعاصاه الزول عايش في
Regarding the 2023 war, things happened that are beyond description in ordinary words. People may not even believe us if we talk about it. Children die of hunger every day. In the same situation of hunger, someone brings their livestock into farm of the same person whose child died of hunger. There are people dying every day, and I apologize for everything that I've been saying. And if a person goes out, there are lots of threats. And some people try to get some livestock in order to eat them. However, they are being under threat in their houses. So they are coming and taking our things away from us. The situation is very bad. So whether we were from Bindisi or from Mukjar. And we can also be subject to some checkpoints where there is danger on us. The situation is very difficult, and we hope that this message will reach the international community that will take these crimes into account and provide relief to the displaced. Because Sudan and the Sudanese people, especially the refugees, need you. So you need to give them justice. You need to help them to recover their rights.
Salah's harrowing account paints a vivid picture of the escalating insecurity, hunger and violence faced by the participating victims in Darfur as the civil war continues. This grim reality is underscored by Aisha, who is a survivor of the charged search and arrest operation in Delej, and now a long-term resident of the large and densely populated Kalma ID camp in South Darfur. She sent the following message by video in October this year, which I will read out, in which she addresses the dire situation of the camp's residents, including the severe reduction in humanitarian aid. Aisha informed us of the following, and I quote, "Previously, humanitarian organizations provided aid to the camp, but due to the renewed conflict between the army and the rapid support forces, the organizations have left and no aid is reaching the camp. We suffer severely from the lack of basic necessities, no water, no food, and we often go 2 days with only one meal. Personally, I am currently pregnant, and there are no services available for pregnant women. I was referred to Niala Hospital for treatment, but I do not have the money to buy medicine to continue the treatment." End of quote. Your Honours are well aware, of course, of the civil war, which has had implications on the schedule of these proceedings. Sadly and unconscionably, however, this largest and most devastating of humanitarian crises received markedly limited attention by the international community and media, a notable difference from the global focus and coordinated humanitarian action that took place in response to the 2003 and 2004 Darfur conflict. No credible path to a cessation of the hostilities or an easing of the humanitarian situation appears to be on the horizon. So now, one may properly ask what relevance the current civil war has to the Darfur conflict of 2003 and 2004. As communicated during our opening statement last year, Your Honours, it is the participating victims who have drawn this connection. During meetings with our team and in numerous video communications transmitted since the outbreak of the civil war, the victims have emphasized that the wholesale impunity for the mass crimes allegedly committed during the 2003 and 2004 conflict has permitted the very same bad actors to hold on to power and now plunge the entirety of Sudan into devastation. The trial chamber has received evidence on these bad actors during the course of the proceedings, namely military, intelligence, and security apparatus of the government of Sudan on the one hand, and the rapid support forces on the other, the latter arising from the Janjaweed militias formerly allied with the government during the 2003 and 2004 conflict. It is a simple yet powerful conclusion that the victims have drawn. Impunity breeds further impunity. The participating victims have expressed the view that the devastating violence, destruction of property and communities, and mass displacement which they and larger for society were subject to during the 2003 and 2004 conflict, would not have prevented the survivors from rebuilding with great effort and through the solidarity for which the four people are known, their lives and livelihoods. The deep wounds wrought by the 2003 and 2004 conflict, including those arising from the four charged incidents in this case, may have healed over time, scars that remain visible, but not a fundamental impediment to a return to a way of life and the customs and traditions that have their roots in the historic Sultanate of Darfur. But this is not what transpired. Your Honours will recall the significant evidence and views received from witnesses and participating victims on how the initial displacement of 2003 and 2004 has stretched into 2 decades of generational trauma. The fertile ancestral lands of the four people, renowned for their skill at farming, seized by some of the Arab tribes from Darfur, as well as members of Arab tribes brought in or welcomed from other African states. The four people relegated to IDP camps in Darfur and refugee camps beyond Sudan's border, unable to rebuild the loss of wealth stored in their homes, livestock, property, and lands, and forced into the three-cornered livelihoods, as you can see on the pictures on this slide, described in the expert report of Professor Alex Deval, where survival depends on a combination of a small-scale subsistence farming, low-income urban activity, and food assistance, if at all. Parents struggle to feed, clothe, and educate their children. Physical insecurity, even prior to the outbreak of civil war, continued to stalk the IDP population. Families, permanently separated, and social bonds and structures indelibly altered. The psychological impact of the killing, sexual violence, torture, and loss of wealth and dignity, always casting a shadow over the victims, without the assistance, and most importantly, the traditional community structures as they used to be before 2003 and 2004, to help them heal and recover. The participating victims can, of course, convey to your Honours with far more eloquence and meaning what has befallen them over the past 2 decades. Khadija, she's a survivor of the charged attack on Kudum, and who lives as a long-term displaced person near the town of Mukjar, sent the following message for Your Honours last month, which we will now play.
In the past, we lived a prosperous life filled with happiness and joy. We had wealth in the form of sheep, cows, camels, and other assets, even transportation methods that helped us continue our lives. One of our traditions was during wedding ceremonies when livestock such as sheep and cows were given as dowry. This helped families secure financial stability for the newlyweds to start a stable life and build a family. Additionally, when we needed to purchase other items like clothing, we often exchanged them for livestock. However, the Janjaweed took all our wealth and left us with nothing. They displaced us to other places in search of safety, but we have not found it to this day. During the search, the village was under siege and 18 men from our family were taken and killed. And they left us, the women. However, they did not limit their actions on men, and during the search, we were about 18 displaced women who were subjected to rape. A large number of us developed severe infections that led to infertility.
Okay, so the video was quicker than the translation. I will, if you allow me, just read the last part of the message. Or the interpreters can do it.
Back in that time, we were girls, and I was one of these girls, and I haven't been able to conceive up to this day because of the rape. I am a victim, and I'm in desperate need of medical treatment. The violations committed by the Janjaweed are too numerous to count and too painful to express in simple words. When I remember these moments, I feel the trauma, and several times I cannot sleep at night, as you see me in the image. However, I want the judges of this court to listen to me. We are living in a very dire situation. We do not have adequate clothes or sufficient food as we lived before. Even finding work has become extremely difficult. We have to take on the hardest jobs in order to survive. Therefore, prosecuting the criminals is crucial to restoring our dignity. We also demand individual and collective compensation for many reasons.
So I think Khadija's words say it all, and it's been very important for us, and obviously you can see that we had to distort the faces of our clients, but we thought that it's important to, to fulfill this promise also we made, that you hear their words, and nothing translated by me, if I may say. So I apologize for the quality, but for obvious reasons, that was the only way of doing it and still bringing some life to the courtroom. So Salah, who addressed Your Honours a few minutes ago by way of video on the impact of the ongoing civil war, also speaks powerfully about the trajectory his young life took after the charged attacks on his home village of Bindisi in August of 2003. And you will hear a second part of her message, of his message, pardon.
دم من معسكر بندس من ضمن الضحايا.
I am from Bindisi camp, and I am one of the victims of what happened in 2003. When the war broke out, I was 13 years old, and up until today, I am over 30 years old. So we faced significant challenges because of these events, and I was deprived from lots of childhood activities during my youth. So I was not able to do lots of things that young people do because of the war. So I had to stay in a forest for 4 days without food or water, and it was fall time, and it was a harsh rainy season. What I would like to say is that after all these things that happened, the impact of the war continues up until today, because I was not able to get education and I am not able to find a decent job. I have to work in traditional farming, and I'm still working in this. But even in agriculture, there are substantial challenges, and we can face lots of difficulties. So all these difficulties that I have faced, I hope that something will give me compensation for what I have lost during that time.
So clearly, Your Honours, you cannot disconnect the situation of the participating victims today, after this long-term displacement, from the events this trial is addressing in 2003 and 2004. In the assessment of the participating victims, and you just heard from Salah, in his own words, the reality that their lives have become over the past 20 years is directly tied to the lack of accountability for persons and actors responsible for the mass crimes documented during the 2003 and 2004 Darfur conflict, and the absence of mechanisms for reconciliation, restitution, and reparation. The participating victims therefore view the present proceedings as long overdue justice for the crimes and harms perpetrated against them, their families, and the wider FOR community arising from the 4 charged incidents in this case, which also are limited in scope. But they are also an important step, however limited, in the broader fight against the impunity that has led Sudan down the path of the ongoing and devastating civil war. As a participating victim named Adam, a survivor of the charged attack on Bindisi, expressed during a meeting, and I quote, "I hope one day we can see all those who committed crimes, including Bashir, standing in front of the judges. We will stay patient until our case ends, and I hope we can meet again in Darfur one day in peace." Let me briefly speak about the victim's role in ICC proceedings. The ICC is often referred to, including by its officials, as the victim's court, owing to the Rome Statute's framework for victim participation and the possibility of reparations in the event of the conviction of an accused person. In our opinion, this designation is one that can only be properly bestowed by the victims themselves, not by officials, not by politicians, not by lawyers of all kinds or journalists. It's a matter of trust and must be earned. It is our assessment that the participating victims, by and large, have placed their trust in the trial chamber's ability to render fair and impartial justice, that also reflects and takes into account the circumstances and views of the victims. The face the participating victims have placed in the court's judicial processes is exemplified, in our view, by their continued willingness to engage with the court and our team over the course of the last 4.5 years. Hauna, she's also a survivor of the charged Bindisi attack, communicated to us that, and I quote, "After waiting for 20 years, we can wait a little longer to see what the judges decide, but it's hard to live in this uncertainty. Still, we are alive and we will continue to wait. We are happy to share information and will keep in touch with the field assistant of the victims team. We will also prepare a message for the judges and follow the trial closely." End of quote. The fact that victims choose to participate in ICC proceedings should not be taken as a given. And clearly the 1,592 that we are representing are probably just a drop in the ocean of the attacks committed in Kudum, Bindisi, Delej, and Mukshar. But most participating victims also live far from the seat of the court, and as I have earlier addressed, in circumstances that are extremely difficult. You will also be aware that most of the participating victims do not have mobile phones and live in parts of eastern Chad and areas of Darfur where the telecommunication infrastructure, even before the outbreak of the civil war, was limited and unreliable. Add to this the length, the complexity and foreign nature of ICC proceedings, and the practical reality of a small legal representative of victims team consulting with and acting on behalf of hundreds of participating victims, each of whom is deserving of being recognized as an individual, not just a number. I raise these points as a plea for humility and understanding from those of us who work or act before this institution, when we consider that victims' participation entails and really means, when we consider what victims' participation entails and really means in proceedings before the International Criminal Court. Victim participation is very much an active process. It was an act of courage by each victim when they filled out an application for participation, reliving the conflict of 2003 and 2004, including the charged incidents. It was an act of trust and self-sacrifice each time a participating victim stepped away from their daily work and responsibilities in farming, manual labor, selling small goods, fetching clean water, caring for children and family, to participate in meetings with our team, and to record video and audio messages communicating their views and concerns, like the ones you just saw and the ones I'm quoting from. In addition to dangers, difficulties, and indignities inflicted by men, the participating victims confined in the IDP and refugee camps that have been their homes for the past 2 decades are also at regular risk of natural disasters, including devastating floods and fires, as discussed in Section 2B of our final brief. Witness V01, I don't know if you remember her, who appeared before your judges in June 2023, recently sent us a video depicting and describing the situation in her refugee camp in eastern Chad, where around half of the Chad-based participating victims reside, and which was entirely submerged by floods in mid-August of this year. All the houses were destroyed. V1 stated the following, and I quote, "We are no longer able to take care of ourselves, neither the elderly nor the young. We cannot even leave this place to go to the nearby village to get food. Even if we manage to reach the town, There are no vegetables or other food available. The floods have destroyed all the crops and produce. Our community has graciously helped and provided some of what they can, but for 6 weeks, no one has come to check on us, not even humanitarian organizations. This camp is in ruins, non-functional, flooded, and starving. Death is close to all of us, and we don't even have kaftans shrouds to bury our dead if people die today. With no organizations able to reach us due to the rains and floods, we can now only ask God to help us. No help from humanitarian organizations, no help from the Chad authorities for weeks and weeks. We have received similar images of flood-devastated IDP camps in the area of Bindisi, as you can see. It's all at the same time, more or less, as well as Kalma camp in South Darfur, which are now on your screen. The IDPs and refugees impacted by these reoccurring weather events have little possibility to leave the camps and must simply rebuild in the same locations when waters finally recede. And this is what is happening now. Start from scratch. Participating victims have also sent us pictures of the fires that regularly sweep through their IDP camps, quickly consuming and spreading among their homes. Your Honours may recall the views conveyed by participating victim V4, a resident of a large IDP camp in Darfur, when he appeared before you in October of last year. V4 explained as follows, and I quote, "The flames eat the houses that are nearby and they create great damage. And if the houses are close to each other, then the fire would spread from a house to the other. In some instances, 20 to 30 houses were burned in one fire. Fires are the biggest problem because when a fire happens, the damage is very big." End of quote. You can also see on the screen, Your Honours, photos sent by the participating victims, the communal house building that takes place in the IDP camps in the wake of such fires. As alluded to in the communication from witness V1 and the views of V4, the participating victims who live as IDPs and refugees must primarily count on themselves and their fellow camp residents to rebuild and to strive to survive in the face of natural and man-made calamities. And notwithstanding these calamities, the participating victims have continued to engage with us throughout these proceedings. It is, in our submission, another testament to the active nature of their participation, no matter the physical distance and immense difficulties that lay between this courtroom and the realities and struggles of their daily lives. You may also recall the determination of participating victim V3, who traveled, along with V1, over difficult roads for 3 days from his refugee camp in eastern Chad to reach the capital of N'Djamena. There, he waited 2 more weeks away from his family and farm before he could travel to appear in person before the trial chamber. On his way back, he forged flooded passes and valleys to return to his refugee camp, missing much of the harvest season in the process. Participating victims V4 and V5 undertook the most trying journey you can imagine, navigating the ongoing civil war in Sudan on their 8-week round trip. Arduous mission to present their views before Your Honours. Participating victim V2, Hassan, who was a child at the time his village of Bindisi was attacked, was the only individual originally from Sudan who appeared under their own name during these proceedings without any protective measures. 6 participating victims also appeared as witnesses called by the prosecution. And another 20 prosecution witnesses were admitted as victims following their testimony before the trial chamber. And I can also inform Your Honours that participating victims and other displaced Darfuris watched yesterday's hearing from Kalma camp, and as I mentioned, continue to do so as I speak. Participating victims have chosen to engage with these proceedings in these various ways because they believe that the pursuit of justice for themselves, for their families and the wider community, and indeed for all victims of Darfur's conflicts over the past 2 decades, impels them to do so. Whether the ICC legal framework is the adequate answer to a meaningful victims' participation, and if a legal representative like me is in a position to even get close to the fulfillment of her mandate in this very case, it's a matter for another discussion. I have my doubts. It's not even practically possible to convey the individual views and concerns of 1,592 individuals to the chamber. And the procedural rights the victims are granted, depending on which perspective you take, are very circumscribed. But I do hope, and I expect, indeed, to see a measurable impact of the participation of the victims to be reflected in the trial chamber's judgment under Article 74 of the statute. What was our approach to these proceedings as legal representative of victims? Throughout these proceedings, we have sought to assist the trial chamber's truth-seeking mandate, which I know is a term that is not adopted by all jurisdictions, but it is in mine and it is here. So that's what we try to do. And we tried to serve as a conduit between the participating victims and Your Honours. In questioning witnesses, as well as in our trial brief and opening statement, we really focused on subjects that are relevant to the Chamber's understanding of the lives and livelihoods, the long and rich history and social structures and traditions of the four people, especially, of course, in the localities of Wadi Sali and Mukjar, in what was at the time West Darfur State. Where the evidence in the record was not, at least in our view, of sufficient clarity or detail, we also pursued lines of questioning concerning the crime base, evidence underlying the four charged incidents, and the immediate and shorter-term impact of the alleged crimes on the participating victims and the wider folk community. We also sought to provide witnesses, including dual status witnesses, an opportunity to address the Chamber on the longer-term implication of the charged incidents, apprise Your Honours on the circumstances in which the participating victims live today, and explain their expectations for these proceedings. In line with the Chamber's directions on the conduct of the proceedings, that's how I see it, and our own understanding of our mandate, we did not, at any moment, enter into matters that directly concerned the guilt or innocence of the accused. And nowhere in our brief will you find the term of anything having or not having been proven beyond a reasonable doubt. This is not to say that the participating victims do not have strong views on this ultimate issue, which is the guilt or innocence of the accused. They most certainly do, of course, as reflected in their application forms and in their communication and consultations with our teams. However, the views of the participating victims in this respect, under this legal framework, as I understand it, are not evidence. And the court's legal framework establishes that the prosecutor and the defense are the primary actors mandated to lead evidence and address the Chamber on the alleged criminal responsibility of Mr. Abd-Al-Rahman, and I want this to be very clear. We, of course, submitted a final brief to Your Honours and try not to endeavour to repeat anything we said there. And actually, any of the quotes that you hear today are not reflected in the trial brief. And there are also a few responses that we want to give in a very limited fashion to the defense brief. But in our final brief, submitted even if very late on 4th of November 2024, we have adhered to this framework. As legal representatives, we have sought to assist the Chamber's mandate by focusing on those aspects of the case legal and factual, that are the most salient or concern to the participating victims, apart from Mr. Abd-Al-Rahman's alleged actions during the period of the 4 charged events. In this regard, we do take issue with the defense's submission in its filing of 5 December 2024 that the inclusion at paragraph 85 of our brief of a one-line quote from a participating victim expressing her incredulity at the accused's primary defense that he was not known by the nickname of Ali Kushaib crosses a so-called red line. The defense, prosecution, and the common legal representative of victims are all in agreement that the views of participating victims cannot be relied on as evidence in determinations of the accused's guilt or innocence, and I've said this before. This quote is not evidence and moreover does not discuss any issues of fact. It is instead fully in accord with the rights of the participating victims under Article 68(3) of the statute. It's a view expressed on a fundamental issue in the case that has been communicated through us. As the preceding submissions in our final brief make clear, it is a specific example of a widespread view expressed by the participating victims, and therefore, as also explained in our brief, a primary reason we decided to make submissions on the matter of the defense's claim of mistaken identification. Having carefully reviewed the prosecution and defense's respective final brief, we stand in full by the legal and factual submissions in both our trial brief and final brief, and I respectfully request that the trial chamber take into account these submissions during the chamber's deliberations in the same and careful and considered manner that we feel the chamber has done in respect of all our written and oral pleadings in these proceedings. There are, however, 6 subjects arising from the defense final brief that we feel compelled to address on behalf of the participating victims. The first is on the fairness of proceedings. Firstly, to make it very clear in our assessment, there is no merit in the defense's continued litany of complaints about the fairness and integrity of the proceedings and its 11th hour application for a permanent stay and acquittal of Mr. Abd-Al-Rahman on this basis. Such an outcome would be clearly, utterly incomprehensible to the participating victims, and in our view, justifiably so. As submitted in section 4 of our final brief, Mr. Abd-Al-Rahman's fair trial rights under Article 67 of the statute have been scrupulously respected, and the trial chamber has extended every reasonable accommodation and support to the defense to prepare and present the accused's case. And indeed, we have not opposed, because we had an understanding for some of the challenges you were facing. The list attached as confidential Annex 1 to the defense final brief includes 15 items which the defense refers to as unresolved legal procedural issues impacting on the fairness of the trial. What the defense calls unresolved issues are, in fact, the operation of the court's legal framework in the manner intended. These issues, as you call it, have been fully ventilated before and definitely determined by your honors, including rejection of defense applications for leave to appeal the chamber's decisions for failure to meet the applicable statutory test. While the defense may disagree with these determinations, and sometimes we need to agree to disagree, it is simply incorrect to refer to them as unresolved. They are not. In respect of the defense's submissions in Part 2, Chapter 2 of its brief, as well as in Annex 2 concerning the nature of Sudan's relationship with the court, non-cooperation and alleged interference in the proceedings, these matters have likewise been definitively addressed and dismissed by the trial chamber or, where relevant, the office of the prosecutor. Further, many of these issues are special, technical, legal and procedural arguments which the chamber, in our view, properly rejected. The defense's claim at paragraphs 53 and 54 of its brief of alleged interference by the Sudanese government in respect of witnesses in these proceedings and breach of the court's confidential communications are unsubstantiated or at least speculative. In our view, the defense's repetition of these rejected claims are unfortunate and risks harming the confidence of current and potential future ICC witnesses and participating victims in the court's ability to protect their confidential information. The defense request for Mr. Abd-Al-Rahman to be acquitted on the basis of these various fair trial claims should, in our view, be wholly dismissed. As the participating victims have communicated to the Chamber, the work of justice represented by these proceedings, which the victims have entrusted to the court, should move forward on the merits. And I hand over to Mr. Shah for further submissions.
Yes, thank you, Ms. von Wistinghausen. Mr. Shah.
Good morning, Madam President. Good morning, Your Honors. As indicated by Ms. von Wistinghausen, I will be addressing three subjects in relation to the defense final brief. The first of which is the defense's challenge to the court's jurisdiction under the principle of legality, which is set out in Part 2, Chapter 1 of the defense brief. Now, our position on the matter of jurisdiction is set out in Section 3 of our final brief, and we fully rely on those submissions, Your Honor. So my intervention today will focus on the defensive submissions on the foreseeability element of the legality test as articulated by the Appeals Chamber in its judgment 503 in these proceedings, as well as the defensive submissions on the Sharia law principle of Hanima. So let me start, Your Honors, by noting that the participating victims have consistently expressed an abiding belief in the criminal and sanctionable nature of the conduct captured by the confirmed charges. Our clients would find the defense position that an individual in the circumstances of the accused would not have understood the charged conduct to be unlawful and subject to prosecution utterly baffling. And we say that the participating victims would be right to be baffled, Your Honors. Under the Appeals Chamber's test, the foreseeability assessment requires taking into account, among other criteria, the flagrantly unlawful nature of the crimes charged and the circumstances of the accused. And this is covered in paragraphs 85 and 88 of the Appeals Chamber judgment. Now, at paragraph 15 of its brief, the defense makes the following submission regarding the foreseeability assessment, and I quote, the seriousness of the alleged offense is not, in and of itself, enough to satisfy the foreseeability criterion, which will not be met if there are good reasons the accused may reasonably have been unaware of their criminal nature. What matters is that the accused must have been able to know that the conduct was criminal without need for reference to any specific provision. End of quote. Firstly, Your Honors, it is not a matter of an offense being serious, as the defense characterizes it. Serious, as defined in the Merriam-Webster dictionary, for example, refers in the present context to having important or dangerous possible consequences. Flagrant, on the other hand, is defined in the same dictionary as, and I quote, so obviously inconsistent with what is right or proper as to appear to be a flouting of law or morality, end of quote. The 31 confirmed charges are exactly this, so obviously illegal and immoral as to render a defendant's claim of lack of understanding of the inherent criminality of the conduct in question unreasonable and unbelievable. the flagrant nature of the alleged conduct in question was confirmed over and over again by the witnesses called during the prosecution's case, who revealed their horror and disbelief at what they had witnessed or directly suffered in and around Kadum, Bindizi, Mukjar, and Delij. Many witnesses also described either attempting to file reports with the police in relation to the charged incidents, or explained that the filing of such reports had been administratively suspended by the government, or would have been futile, as the police were themselves powerless. This dynamic was addressed at paragraphs 111 to 115 of our trial brief. Dual status witness P0984 explained, for example, and I quote, "During that time in 2003 and 2004, no, there were certain things that were not allowed at all. So reporting to the police, no, that did not exist at all." End of quote. That's transcript 67, page 19, lines 3 to 8, Your Honors. It was clear in the testimonies of these witnesses, however, that they perceived and understood what they had witnessed or personally suffered were unlawful and immoral acts, flagrant acts. In its closing submissions yesterday, the prosecution highlighted the significant evidence received on the scope and substance of the accused military service, as well as the knowledge and implementation of international humanitarian law in the Sudanese military context, both prior to and during the time of the accused service. For sake of argument, Your Honors, let us set all that evidence aside and accept, for the moment, the defense's position that the accused was a simple pharmacist in Garcilla, whose prior military career was limited to medical duties. Even then, in our submission, an individual in such circumstances, a regular Darfuri citizen, would have been well aware of the flagrant and therefore morally transgressing and obviously unlawful nature of the charged conduct. Indeed, the defense appears to admit as much. At paragraph 187 of its brief, the defense asked the chamber to infer that Mr. Abd-Al-Rahman, and I quote, had a strong desire and interest to establish his innocence of the terrible allegations that had been made against him in the 2007 ICC arrest warrant. We agree that these are terrible allegations, so obviously morally reprehensible that a normal person in the accused circumstances would have been reasonably capable of taking steps to comprehend and comply with their obligations under the law and capable of appreciating the attendant penal consequences, quoting from the appeals chamber judgment. Second, Your Honors, at paragraph 27 of its brief, the defense points to, among other things, the application of amnesties and immunities in the Sudanese military context, the use of torture and execution without trial, and a general lack of prosecution for international humanitarian law violations routinely committed as part of military operations in Sudan. The defense admits that this context must result in Your Honor's finding that an individual in the accused circumstances could not have reasonably foreseen prosecution for the charged conduct. Now, even if the defense's characterization is correct, this has little bearing on the foreseeability assessment. The test does not involve, in our understanding, a rule that a practice of impunity for violations of the relevant criminal law or the clear abrogation of procedural rights results in an individual being unable to reasonably foresee prosecution and sanction for flagrant acts. To put it in a more colloquial fashion, the test is not whether a reasonable person in the circumstances of the accused would understand that they may violate the law because they're likely to get away with it. Instead, the assessment is whether it was reasonably foreseeable that such an individual would have understood that their conduct violates the law and therefore could be subject to prosecution and sanction. As noted we agree with the defense that the conduct alleged constitute terrible allegations for which prosecution and sanction would have been clearly foreseeable. The final issue I will touch on regarding the defense jurisdiction challenge is the Sharia law principle of hanima, which is relied on in the same paragraph of the defense brief, paragraph 27, and further discussed at paragraph 257. According to the defense's interpretation on the meaning and application of this principle within the Sudanese legal and military context in 2003 and 2004, and I quote, "The pillaging of villages identified by the authorities as enemy sites was permitted," end of quote. This interpretation, in our view, Your Honors, misconstrues the evidence. As addressed at paragraph 50 of our final brief, the submitted evidence, including the testimony of D16, establishes that the application of hanima under the Sudanese Armed Forces Act of 1986 was strictly limited to the camps of the enemy, which was specifically defined under Article 3 of that act as, and I quote, "external enemies, outlaw rebels, and armed gangs in a state of readiness for combat operations," end of quote. Under no reasonable understanding of the law could a civilian village and its population be lawfully designated by fiat as the camp of the enemy, as the defense proposes. Even the defense's own expert witness, D23, conceded that, at the very least, the enemy in this context could not include women and children. And that is at transcript 142, page 74, line 15, to page 75, line 23. So it is our firm submission, Your Honors, that the common sense view of the participating victims is strongly supported by the relevant law and facts. The court has properly exercised jurisdiction over the accused, and Your Honors should proceed to consider the case on the merits. And should Your Honors do so, you will first have to consider and determine the threshold issue in primary defense put forward by the accused, that he is not the same individual identified by the nickname Ali Kushayev. Now, this primary defense is addressed at Section 5 of our final brief and in Section B of the prosecution final brief, which the prosecution further expanded upon in its closing arguments yesterday. We have little more to add to these detailed factual submissions, Your Honor. The additional value that the participating victims may bring to this subject is to caution Your Honors to apply a measure of common sense and to take into account the relevant context when assessing the evidence relevant to the issue of the accused's identity. In the understanding of the participating victims, and as agreed by the parties and further established by the evidence, the accused is not alleged to have been an outsider newly arrived in the Wadi Salah locality in 2003. Instead, he had been well established in the town of Garcilla for a number of years prior to 2003, perhaps for longer than a decade, and a familiar presence in the area for many years before that. Further, the evidence establishes that the core biographical details of the accused and the individual repeatedly identified as Ali Kushayev are a carbon copy. Given these basic realities and context, the defense's position that individuals in and around the Garcilla community and those who would visit Garcilla could possibly be mistaken, confused, or involved in a shadowy mass conspiracy in wrongly ascribing something as basic as a nickname to the accused is a puzzling notion to the participating victims. In our assessment, the victim's intuitive response is well and convincingly supported in the evidentiary record. The accused was known by the nickname Ali Kushayev for many years prior to 2003. Your Honors, I will now briefly touch on a matter in the defense brief that is relevant to the submissions in section 6 of our final brief, which addresses in part the protected status of the predominantly fur populations of Kadum and Bendizi under international humanitarian law. At paragraphs 357 and 358 of its final brief, the defense discusses the broader context in which the charged attacks on Kadum and Bendizi took place, noting, among other things, the reported presence of rebel forces in the Wadi Salah and Mukhtar localities. The last sentence of paragraph 358 relies on and quotes from the statement of witness P87, namely that the attack on Kadum and surrounding areas was an, I quote, an incident where the area was held by rebels when the government forces attacked, end of quote. And this is DAR OTP 0133-0573 at paragraph 157. Now, during its submissions yesterday at real-time transcript page 90, the prosecution noted that the municipality referred to by the witness is spelled K-U-T-U-M, Khartoum, which is located in North Darfur State, hundreds of kilometers away from Kadum. However, even presuming the witness intended to refer to the charged attack on Kadum, it is telling, Your Honors, that the defense chose not to rely on the very next paragraph of the witness's statement. And at paragraph 188, the witness testified that he does, and I quote, not have any information about rebels operating in the villages at the time when they were attacked, end of quote. He further states that as far as he is aware, and I quote, the rebels tried to avoid staying among the villagers because they knew that the government would attack the villages. Villagers might have provided food and supplies to the rebels on an individual basis, but they did not harbor them in their villages, end of quote. Now, this evidence, omitted by the defense, is exactly in line with the submissions in section 6 of our final brief. The submitted evidence convincingly establishes that rebel forces were not present in or around Kadum, Bendizi, and the other predominantly fur villages that were attacked on 15 and 16 August 2003. Instead, as alleged in the confirmed charges, the predominantly fur civilian population was the intended target of those attacks. Thank you for your attention, Your Honors. With your leave, I will hand the floor back to Ms. von Vistinghausen.
Yes, thank you very much, Mr. Shah.
Right, time is running, and I realize again that time management is not my thing, but so I'll move on. I would like to say a few words about persecution, because that's important to our clients. There is this topic related to the motive behind and nature of the four charged incidents that I want to turn your honors to attention to in respect of counts 21 and 23 of the confirmed charges, alleging persecution on ethnic, political, and gender grounds as a crime against humanity. The participating victims are of the strong belief that they and their communities were targeted by their own government and allied local militias on the basis of their immutable ethnic and gender identities and for their perceived support of the rebel movements. These charges are perhaps the most painful and cut most deeply of all for the participating victims, as they were allegedly perpetrated through the other offenses charged in each of the four incidents. It is maybe worth recalling the evidence of Professor Deval, who explained that the concept of an African Darfuri identity as an opposite to an Arab Darfuri identity is a social construct that only came into being in the 1980s, just a few years before the outbreak of the Civil War. You may recall that several witnesses gave evidence on their good relations with members of the Arab tribes who lived in or around their shared communities. Dual status witness P0585, for example, testified, and I quote, "We also had a really good relationship with the Arab tribes because we were partners in trading and in other matters. But unfortunately, after the government started using the Arabs against us, things deteriorated," end of quote. The three counts of persecution in these proceedings as well as the wider context of the 2003 and 2004 conflict in which they occurred, are properly viewed in light of this historical and social background. Haroun, a survivor of the charged attack on Bindisi, encapsulated the deep-seated nature of the harm arising from the alleged crime of persecution in a video message sent to us in October 2024.
What happened here in Bindisi is well known to us. All the criminals are known, and we know them one by one. There are big names that made the plans and small groups that carried them out. These groups committed terrible acts against the people because they knew them well. Even the personal belongings inside our homes were looted. We lived in the same area with them, sharing joy and sorrow, but they betrayed us, burned our homes, and looted our money. When we returned to Mukjar at night to gather food, they would attack us with utmost brutality. Imagine someone you know well attacking you just because of your ethnicity. We were attacked because we are from the Fur tribe, while the attackers were from other tribes. The government gave them the green light to do whatever they wanted to us. They were told that we deserved death, and our money was considered spoils for them. The worst violations were committed against women, including making them crawl on the ground under the soldiers' legs, enduring obscene insults, beating, and whippings. Our message to the court is that we do not want these criminals living among us. They betrayed us, and they should be held accountable.
We would like to address Your Honours on the defence's submissions at paragraph 542 to 544 on its final brief related to the Mukjar charged incident, and paragraph 646 to 650 concerning the Delej charged incidents. The defense contends in essence that no persecution occurred on the basis of ethnic, political and gender grounds because the identification and detention of predominantly 4 males was sufficiently specific. The defense points to evidence of the search and arrest operations being aimed at 4 males who had arrived from outside of Mukjar and Delej, who could have been members of the predominantly 4 SLMA rebel forces. And the defense further refers to evidence that lists of suspected members of the rebel forces were utilized. Not all 4 males falling into this category were in fact detained. Some of the detained were eventually released, and that 4 males who were residents at Mukjar or Delej were by and large not detained. The prosecution touched on this yesterday. In our view as well, Your Honours, the defense position minimizes the impact of the preceding widespread attacks on predominantly 4 villages in the area surrounding Mukjar and Delej. It was not only the 4 population residing in the Sindhu area where SLMA forces were based that had fled to Mukjar and Delej seeking shelter, but thousands of other predominantly 4 civilians, some of whom had also fled to the Sindhu area following attacks on their villages. The defense's suggestion of a carefully calibrated selection criteria falls away in the face of these facts. Given the noted context of mass force displacement targeted the 4 population in the surrounding areas and the relatively small number of organized SLA forces in West Darfur state, the evidence, in our view, establishes that an essential component relied upon by the detaining forces was the unlawful criteria of ethnicity, gender, and perceived political affiliation. It is our submissions that the legal and factual elements of the crime against humanity of persecution on the basis of ethnicity, gender, and political affiliation are well established. These men were only detained, tortured, some of them executed, because they were Fur and because they were men who had formerly been separated from their families. There is no doubt about this in the view of our clients. We also note, Your Honours, that this case marks the first instance in which the trial chamber of the court will consider allegations of gender persecution as a crime against humanity targeting males. So it is our submission that the Chamber's elucidation of the law in this area may also advance the cause of justice beyond the contours of these proceedings. Very briefly about the contamination of evidence, the last topic that we wish to address in relation to the defense's final brief. The defense submits that the apparent corroborating evidence given by numerous witnesses is a case of, and I quote, collective memory of witnesses living close to each other for many years after the events and before giving their evidence, and therefore is not a speculation, but a reinforced presumption. Of the 9 witnesses whose accounts the defense challenge on this basis, 7 are participating victims, with 2 holding this status when they testified, and the others afterwards. And this is why I think I need to address this. These are my clients. In their closing submissions yesterday, the prosecution answered in detail the defense's challenge, and we do not intend to cover the same ground. But instead, we wish to address Your Honours on the larger point of principle that the defense asserts. From the perspective of the participating victims, the notion that their recollection of traumatic events in their lives and the lives of their community should be presumed to be untruthful on account of having been forcibly displaced from their homes into IDP camps and refugee camps for the last 2 decades would be a confounding and bitter pill to swallow. The defense cites to no jurisprudential support for its proposed presumption that the evidence of displaced persons who may live in close proximity to one another, and yes, over 2 decades, should be presumed contaminated and unreliable. There is no evidence whatsoever in this trial that comes even close to what we have seen in ICTR cases, for example, and what has been discussed in other cases before this court, and where there was evidence that at least was presented to the judges, whatever they will do with it, but there was nothing of the like in this case, and it's really needs to be rejected on behalf of our clients. I'm jumping a little bit, but just to summarize, I don't think that we have seen any indication for what we call a collective memory. I know we all have this ICTR experience, and there it was a big topic, and it's reflected in many of the judgments, but I can't see anything of that kind, or even the slightest indication of the influence by survivors' organizations or anything alike that indeed, we've seen in other situations, but not here. So it is our submission that Your Honours should reject the presumption proposed by the defense and consider the evidence of the 9 witnesses in question pursuant to the normal rules of evidence assessment. I will move on to actually an important part of my closing statement, which is views, expectations, harm, and suffered by the participating victims. You have already heard today from several participating victims. In our trial brief and in the opening statement and final brief, we have explained in great detail the different types of harm suffered by the victims, be it psychological, physical, material, be it long-term or short-term, be it very personal or an infliction on the whole community, be it different from one generation to another. And I urge Your Honours to take this into consideration when reflecting on the views and concerns of the victims and the impact of the crimes allegedly committed. So I won't repeat what has already been said. However, given the growing number of participating victims throughout the trial proceedings, now more than double the number than at the time of our opening statement, it is of importance to us to reflect as many personal statements from victims who weren't quoted in our previous submissions, as many as can possibly fit in this limited closing statement. In every single meeting with clients, and there were many, the victims spoke out. Many sent us voice and video messages. One promise I made to them is to convey to Your Honours exactly these words, without rephrasing. So let's first speak about life in the full community prior to the conflict, and how the loss of homes, as well as long-term displacement, impacted our clients' lives. The attacks on Binisi and Kudum, as well as uncharged attacks on the villages of participating victims, left more than physical ruins. It dismantled the social foundation that defined these communities. Umran, for example, a survivor of the Kudum attack, explained to us in a video meeting, and I quote, For many parents, watching their children grow up in an environment detached from their heritage is deeply painful. The generational gap in cultural knowledge has left younger generations without a connection to their roots, as the customs and values once passed down in the community are now difficult to maintain in camps. Haroun, now displaced in Delej, says in a video communication, and I quote, "Life was beautiful, full of joy, with family and loved ones close. Now we live scattered, some as refugees in other countries, others in distant camps." And Hawa expresses, we were once respected. We had dignity, but now in these camps we are treated as if we are worth nothing. And Fatima sent a message in February 2024 stating that it is as if they have erased who we were. Every time we try to hold onto something, it is taken away. Haroun, an IDP in Delej, shared his positive memories in a video message. "Our previous life was one of the best, with our parents raising us well because we had all the comforts and security. We enjoyed the company of family and loved ones. And we also received education, both formal schooling and informal education in religious schools in our homes, taught by our parents." End of quote. And Ismail says, and I quote, "Previously, we had everything and lived our lives normally, sharing joys and sorrows with everyone. However, after we were attacked by militias, everything changed. The militias took everything we owned and destroyed what was left in the village. Now, only traces of destruction and ruin remains." Hawa, she's a refugee in Chad, said in a virtual meeting in July 2024, and I quote, "Before the war, every household had enough space to host people. But now we don't have enough beds for our own family members. It's destroying the way we used to live. We can't help each other the way we used to. And it's tearing our social fabric apart." End of quote. Amina, she's from a refugee camp in Chad, says, and I quote, "The war has divided us. I still have family members in other camps in Sudan. I don't know how they are doing, just like they don't know about me. Living in the camp is one of the worst lives on earth, and it's only getting worse. I worry about our country. I fear that we've lost it and may never get it back. All I want is to return home." Highlighting the prolonged challenges faced by the community, Mohammed emphasized the enduring lack of security while displaced, stating, and I quote, "Even in displacement camps, we are still being persecuted." All these messages say everything in simple words about the consequences of long-term displacement from one's homes and ancestral lands. Life in IDP and refugee camps for over 2 decades has proven to be a continuous extension of the suffering of the victims. As we all know, and like in almost every armed conflict, violence in Darfur included systematic gender-based and other crimes that inflicted deep physical, emotional, and psychological scars on many women. In particular, witness V01 and participating victim V05 addressed you on this subject in detail when appearing before Your Honours during the presentation of the victim's case. The difficulty of addressing rape in the Darfur and larger Darfuri community is compounded by cultural and social stigmas that surround the subject. To preserve the dignity of the survivors and allow them to reintegrate into society without the weight of shame, the community avoids openly discussing these events. For example, Noor, a survivor of the Kudum attack, who suffers from depression, speaks about the loss of her father, but also refers to the violation of her dignity, as she says, and I quote, "We, my elder sister, my father's wife, and I, buried him ourselves to honor his soul. I was beaten, insulted, and my dignity was violated. Because of the blows to my head, I still feel pain to this day." End of quote. And I think it's not difficult for us to interpret what she means by these words. Alawiya, also from Kudum, recounted in a straightforward video message the ordeal faced during her displacement to Mukhtar. She says, and I quote, "We suffered severe humiliation, especially the women. There were cases of rape, miscarriages, family separation, and panic among the displaced. Many children and elderly died due to diarrhea, and there was a great shortage of food and clothing as it was the rainy season." End of quote. And reflecting on the inhumane treatment, she added, "We were beaten and treated worse than animals, as if we weren't human beings. Dogs are only stoned, but we were beaten with sticks and weapons. The violations continue to this day. Medical services, especially for pregnant women, are unavailable." End of quote. Fatima, another former resident of Kudum, recounted the profound trauma of losing her child during the attack on her village. And I quote, "We tried to escape, but as women it was impossible to outrun these horses and camels. I stayed there for an entire day, and as a result my child died to the water and humidity." This is what happened to her when she entered a water pond carrying her infant on her back. The prolonged exposure left her ill, and she described the conditions as marked by, and I quote, "hunger, deadly diseases, and extremely harsh conditions." Despite the unbroken solidarity and resilience amongst these women, that is truly impressive when you speak with them, the daily struggle is evident in many exchanges. Halima recounted in a virtual meeting in July of this year, and I quote, "It's harder for us to help each other like we used to. We try to gather women to work on farms, and then we distribute what we harvest to those in need, but the situation is becoming unbearable. Everyone is exhausted. There's no food, no medicine, no water. We share what little we have with the animals so they can help us farm. We are truly on our own." End of quote. On their own, Your Honours, yet still brimming with incredible hope for the future, resilience, and even moments of good humor. I will never forget a dialogue I had with 4 women in Kudum in a video meeting earlier this year. They recounted how they would no longer leave the IDP camps and work in the fields and sell their products like onions at the market. For security reasons, can't leave the camps anymore. Yet, instead of self-pity, to the contrary, really, they embraced humility and creativity. And they told me that they were now collecting ingredients for perfume that they now proudly sell at the market for little money or in exchange for other goods to be able to feed their families. A truly beautiful attitude, I find. She says, they said, "We have had to rely on each other. We share what little we have, and we support each other because there is no one else." And this is Fatima speaking in a meeting with us. I'm aware of the time. Yeah? Okay. Thank you. Children, and I have to speak about children, as the most vulnerable members in the community and as briefly touched on earlier, suffer a specific and devastating type of victimhood. Be it because they were children during the charged events or because they were born and have grown up in IDP and refugee camps with all the scarcities it implicates. Some also carry the stigma of being children born out of rape, adding layers of trauma to their already dire circumstances and environment. Yusuf, he's a survivor of the Bindisi attack, addresses these impacts on children in a video that he sent us, and he says, "I am speaking about the effects of war on children, the suffering of children who are the most vulnerable group in society and the most affected during wars and disasters. This is because they depend on others. At the same time, children and pregnant women cannot endure the harsh conditions that come with war, such as hunger and diseases. In this context, I must highlight that there were many cases of miscarriages during the war due to the lack of sufficient food, the sound of gunfire and other circumstances, such as walking long distances on foot, running, stress, and fear. Such conditions are unsuitable for pregnant women and children, leading to harmful consequences for pregnant women. End of quote. He also noted the psychological and behavioral consequences for children by saying, there were many cases of malnutrition among the displaced population. Violence also emerged amongst children, influenced by their exposure to ongoing events, which they began to mimic. For example, the appearance of children carrying and using weapons. End of quote. Asma described, and she was a child during 2003 and 2004, the persistent hardships, particularly on children during her displacement journey and in IDP camps. And she said, I quote, "We reached Mukja, but the situation there was very difficult. There was malnutrition among children due to the lack of sufficient food at that time. We went to Niala searching for a better life, but the circumstances did not change, so we returned to Mindisi. Now, we are settled in Mindisi camp, but the lack of healthcare and education services has greatly impacted us, along with the absence of security in the region." And Taiba, also displaced as a child, painted a haunting picture of her early years, and I quote, "We were small children and we fled to the forest with our mothers. We lived under extremely harsh conditions during the war. We cried from hunger, the sounds of gunfire, and the rain." End of quote. The repeated displacements and violations left lasting scars, robbing her of both her childhood and her aspirations. And she's only one sad example. She says, "I had a strong desire to become a teacher, but I ended up as an ordinary housewife," she lamented. The worsening economic desperation since the outbreak of the ongoing civil war has led to unimaginable choices. Haroon recounted on an unprecedented situation, as he called it, that illustrates the depth of hopelessness, and I quote, "A person tried to barter his children for money to improve his economic situation. This reflects the severity of the circumstances. You cannot take your child to the market to trade them for food to save the rest of the family from extreme hunger." End of quote. Alawiya reflected on the long-term consequences for children growing up in the camps when she said, and I quote, "All services like education and health have been completely stopped. Children are growing up without education, leading to negative behaviors among the youth, such as unemployment, drug abuse, theft, child recruitment, illegal migration, and involvement in dangerous jobs without supervision." End of quote. Her plea underscored the need for accountability. And she says, "We need dignity and a safe life. We want to return to our villages and live in peace without fear. This will only happen after the criminals are held accountable." End of quote. The stories of these children and their families highlight the enduring and intergenerational harm caused by the conflict. The lack of access to education, health services, and security, combined with the trauma of violence and displacement, has robbed countless children of their potential futures. And Your Honours, I will be very honest with you, and I will ask you for a bit more time that I've been allocated, because I still have to speak about malnutrition, psychological harm, and the expectations from the court. I'm aware that this is maybe an unusual request, but I'm representing many people, as I said. Much of this was only received in the last weeks, couldn't even go into the brief, and I think I really want to fulfill the promise I made that I can convey these quotes to you. So maybe this is something.
How much longer are you asking for?
"20 minutes, I think."
All right, Mr. Lauchi, you asked for extra time, and we declined it because we thought you had sufficient. And part of the reason that you asked for was to deal with the matters that the CLRV were dealing with. What we'll say is this. We will give Ms. von Vistinghausen the extra 20 minutes. It's right that the victims sometimes get lost, I think, in these trials, and I think she should have the time, but we will therefore increase your time by a further 20 minutes.
Even with that, without that condition, we would not have objected, but it's welcome.
Yeah, right. Yes, all right. Well, in that case, we'll take the break now, Ms. von Vistinghausen. We'll sit again at, I suppose we better allow the extra 5 minutes because of the time lag, at 20 to 12. So that means we would expect you to finish by midday.
Yes, thank you. It's very much appreciated.
All right.
Thank you.
Yes, very well. We'll adjourn until 20 to 12.
All rise, we will.